Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Hello. How are you? Oh, pretty good. How are you?
Mess last night.
Yes.
Rosie almost horrible. I was in bed last night. It was like, I tell you what, I'm glad I wasn't driving too much.
25-248, which is Mitchell Brown versus Diahanne Morse. I see counsel are present. I'm assuming ready to proceed. We are being streamed live on the web, both by audio and by video. Before we begin the argument, I would ask counsel to please identify yourselves for the record, including the party you represent, starting with the appellant.
Yes, I'm Susan Thiem. I represent the appellant, Diahanne Morse, and she's here in the courtroom as well. Thank you.
I'm Jesse Bifulco. I represent the appellee, Mitchell Brown.
Thank you. And Attorney Thiem, if you are ready to proceed, we'd be happy to hear your argument this morning.
Yes, I am. We're here today to argue a number of issues. First off, and most important, is whether or not the partial summary judgment should have been granted. As of course the court is aware, it's a de novo review of any summary judgment. In this particular case, the basis of our argument is that there are multiple genuine issues of material fact. First off, there is the issue of the duplicate signature pages. This goes to the factual dispute as to whether or not Tina Bowden, deceased, could have used a pre-existing power of attorney, which was prepared by the same attorney who prepared the trust, and whether or not Attorney Moser had doubts about whether or not the settler was competent, because he had her sign both, she signed under the power of attorney for the trustee, Cecil Armstrong, and he signed a separate certification as well. The second issue of whether or not Mitchell Brown was serving as the trustee at the time of the death of the settler in spite of his prior resignation as trustee. The language in the trust, at least it's our position, requires the trustee to be serving at the time of the death of the settler. The third issue is the question of latches. This is raised as a defense in the answer and in the additional statement of material facts. And the appellee did not respond at all to the additional statements of material fact, and pursuant to Rule 56H4, those facts shall be presumed to be deemed as admitted. The fourth issue as to the summary judgment is the issue of whether or not the amendment and latches applied. The appellee knew about the amendment and the appointment of the successor trustee back in January of 2020 when Tina Bowden was still alive, and could have addressed the issue at that time. This was stated in the additional statements of additional statements of fact, which appellee did not controvert. The court made no finding on the issue of latches. And finally, as far as the summary judgment, there is the further issue of whether a trust could be amended by a pre-existing power of attorney pursuant to 18B, Section 411 and 412. Additional statements of fact provided that there were duplicate signature pages, which raised the genuine issue of material fact in regard to whether Tina Bowden was advised that she could sign the amendment, since the attorney preparing the trust had her sign for the creation of the trust, and she also signed under the power of attorney the fee agreement between Cecil Armstrong and Joe Mosier for the preparation of the trust.
Counsel, I see that the green light is on. Could you address the issue we asked you to address about whether there was even a final judgment in this case? And
yes, I can.
And hence whether we are able to address the matter?
Okay, I certainly can do that as soon as I can. Sorry, I can't get my paper to turn here. Okay, the final order. The judge's order states that With plaintiff's other claims now having been dismissed, there are no issues before this court to be adjudicated. The order also says the partial summary judgment is the final judgment. And then again reiterates that, this is a quote from that order, this is intended as a final judgment in this matter alone, because there was a companion case. And finally, the docket, which is in the appendix, states, quote, final judgment, case closed. Certainly if we refer to the Sanborn case, it talks about whether or not all issues have been decided, and that would determine whether it's a final judgment.
Yes.
The intent clearly in that order was that it was final.
Let me be clear, though, it says that. But what was not explicitly addressed, and I'm not sure how they were implicitly addressed, are some of the remaining counts, for example, from the amended complaint. In particular, count 5, which is a fraud claim against Ms. Morse individually, or count 6, which is a negligence claim. Now, so count 7 is a declaratory judgment, so one could argue that that was subsumed into count 1 in the declaration of Mr. Brown as the trustee, although it's not clear, but one could make that argument. But do you see anything addressing the either in the motions underlying the judgment or in the judgment addressing the claim of fraud brought individually, or any claims brought individually against Ms. Morse? In other words, the original complaint was only against Ms. Morse in her capacities as personal representative and as trustee. And the amended complaint added multiple counts against her individually, including a claim for fraud.
Well, this particular order issued by the judge, granted it's not the clearest order, and most of the orders in this case were a little ambiguous, but I believe by the judge indicating that with plaintiff's other claims now having been dismissed, that addresses those two claims, because it was the intent of as far as the judge was concerned, this case was over. And that even though he didn't explicitly say, oh, we need to include those counts, he went above and beyond what the motion was on those particular counts to say all the issues have been resolved. So as far as the court was concerned, this matter was over.
Do you have any authority for the proposition that just because the trial court says it's final, it is final, even if the judgment doesn't deal with some of the pending claims?
Well, other than support the Sanborn case, which in essence says, talks about it not being a final judgment when it hasn't addressed all the issues. In this particular case, the judge said all the issues have been resolved.
So what was the judge's resolution of the fraud claim against her in count 5?
It was dismissed.
Show me how it was dismissed.
Well, I guess it was dismissed in the sense that the plaintiff.
And what was it dismissed for? Why was it dismissed?
The judge doesn't reference any of the other claims as being dismissed, but the motion to dismiss the claims that was filed by the appellee
Address counts 1, 2, 3, and 4.
But it also indicated in the body of that motion that it's come to his attention after 4 years that there was not any mismanagement, fraud, or anything of that sort. And so there was no longer any issue, and that he indicated in his motion to dismiss that the summary judgment answered those questions. I might also add that certainly under the theory of conserving judicial powers, if this case was to go back to the court, we'd have to go back to the court, and already Justice Billings, I believe, has made it clear that this case is over. And then we'd have to file a motion to say, clarify how it's over, because the docket says final judgment, case closed. I mean, I've never actually seen it, seen a judge do that, but that docket, which is part of the appendix, last entry in there says final judgment, case closed. And so I think a the appellant, it's reasonable to rely on what the judge says in his order, that he didn't address every item. I mean, this is indicative of how this case went. When we had the issue of latches, that was never addressed, even though it was raised.
Counsel, excuse me, I'm looking at the plaintiff's motion to dismiss
Yeah,
in the appendix at pages 65 and 66.
okay.
And the motion to dismiss identifies the counts, counts 1, 2, 3, and 4. The court, in the last sentence, says the only remaining claims against the estate are for an accounting for her action taken during her tenure as trustee. Is it possible that the trial court just overlooked counts 5 and 6? He didn't. He doesn't. It's not mentioned in the motion.
Right.
It's not mentioned in the dismissal order.
It is a possibility. Like I said, there were very few orders in this case, and they were generally quite brief. And if there was a motion filed, we'd get motion denied. And so I think the judge, at this point, he looked at the motion to dismiss, saw the reasoning was because the appellee felt that all the issues had been addressed, and just blanket dismissed it without prejudice, which of course is another one of our issues. And so I think that we have to look at the intent of the judge. He intended this to be a final order.
Well, if he intended that but didn't do it, to the extent that it's not a final judgment, are there any exceptions that would allow this court to undertake this appeal in that circumstance?
Well, I think I mentioned the fact of judicial economy, that it's clear that this judge thinks the case is over. That's why.
But if we say it's not over,
Then-
how is it judicial economy for us to address
Well, because
it?
then we have to go back down and file Mr. Bifalco would have to file a motion to say, I meant for all the claims to be done, and the judge will, unfortunately, sometimes it'll be months before we get an order that says, I already said it was final, it's final.
I'm not following how addressing it now then, as opposed to requiring it to be final in the first place. If the exception for judicial economy assumes that it isn't a final judgment, but you should address it now anyway, even though there's more to be done afterwards.
Well, I don't, and then when you hear from Mr. Bifalco, based on what he wrote in his memorandum, he's of the position that this had been a final judgment on the summary judgment and on the whole case, in fact, that it's, as far as the judge is concerned, it's closed.
Thank you. We're happy to hear your argument.
Your Honors, if the court concludes that the Superior Court's judgment was not technically final, this appeal is nevertheless properly before the court under the collateral order exception, as applied in a case called Fleet Bank versus Zimmelman. In Zimmelman, the law court held that an interlocutory order is immediately appealable where it satisfies 3 criteria. The issue is separable and collateral to the merits. It presents an important and unsettled question of law, and the rights at stake will be irreparably lost without immediate review. The court emphasized that a ruling which threatens to deprive a party of a legal right that cannot be restored after final judgment must be reviewable now, not later. This case fits that framework. The trustee status question is completely collateral to the dismissed claims, but also to the fraud tort claim, and purely legal in nature, turning solely on the trust's express terms and the effect of the invalid amendment. It is also an unsettled question as applied here, although in our appellee's brief, I don't believe it's an unsettled question. I think we're just talking about black letter law, but if you take the appellant's argument about the underlying appeal, it's an unsettled question about an important issue. Whether or not an amendment executed by an agent without authority can create trustee succession. And finally, waiting until a later procedural stage would irreparably deprive the appellant of the very right she seeks to vindicate, the claimed legal status as trustee. Trustee status is inherently time sensitive. Once the administration of the trust proceeds under a different fiduciary, that right cannot be retroactively restored. Just as in Zimmelman, the court recognized that denying immediate review would destroy the appellant bank's security interest, here, a delaying review would destroy the claimed fiduciary authority itself. You can't administer the trust twice. One fiduciary trustee administers it, that's it, it's over, you can't come back. That loss cannot be remedied after a final judgment. Accordingly, under the criteria reaffirmed in the Zimmelman case, the collateral order exception provides a proper and narrow basis for this court's jurisdiction, even if the Superior Court's order was deemed interlocutory. And also, I think it falls under the death knell exception, because we have, again, you know, the theme that runs through those both of those exceptions is that there's going to be irreparable harm that can't be remedied by the final order. Okay, so it fits the narrow death knell exception because delaying review would irreparably destroy the very right at issue, appellant's claim status as trustee, just as delaying review in a case called Cop v. Liberty, that's 2003 ME 43, would have irreparably destroyed.
The green light is on.
Yes.
So what's your position as to what happened to counts 5, 6, and 7?
Your Honor, I don't know. I do think it was the intention to have all of the counts that were not disposed of by the partial summary judgment order were either going to be dismissed without prejudice.
Well, it was your motion to dismiss, and you specifically asked to dismiss only part of count 1 and then counts 2, 3, and 4. You didn't ask to dismiss 5, 6, or 7.
Oh, I understand, Justice, and I understand that very well. And in reviewing the pleadings for this argument, I did realize that one of the tort claims was not voluntarily dismissed with the court's permission as it was meant to be under the motion. So I believe it was our intention to request.
Is it still your intent to dismiss the remaining claims?
Without prejudice, yes, Your Honor. That's my client's position.
If we sent it back to the trial court, would you in fact be filed for that purpose? Would you simply file a dismissal of all remaining claims?
It's my client's intention.
You don't have to. I'm asking. This is
Yeah.
not a, you know, it's up to you. They're your claims. You have a claim for fraud, a claim for
yeah.
negligence.
I understand, Your Honor. I think that the reason they were dismissed without prejudice was to preserve the rights of the trust to pursue claims if there were extant claims. We may have statute of limitations issues at this point. You know, in prior discussions with appellant's counsel, it was brought to our attention that the act of advising the trustee to alter the trust under a power of attorney would constitute malpractice in the event that this appeal was unsuccessful and that the trust might bring proceedings against her for that. And it was pointed out that that was a direct conflict of interest to continue to represent her. Those are all live issues if the statute of limitations has not run.
Okay, so it's not. So you're not necessarily interested in dismissing all the claims it's in. You don't. And again, to be clear, I'm not suggesting you need to be. I'm just trying to find out.
Well, Your Honor, it was my client's intention to voluntarily dismiss the fraud claim against his niece. Yes.
Okay. Do you agree that that hasn't happened?
I thought it had until I reviewed the pleadings again and reflected on the court's recent admonition to be prepared to argue exceptions. And when I re-reviewed the documents, unfortunately, it came to my attention that that fraud claim was not voluntarily dismissed, but it was my client's intention to do so.
But not necessarily any longer because of the passage of time and concern about the statute of limitations?
That would be a claim against counsel, not against...
Well, I know. I'm trying to understand
Yes, Your Honor.
what you're saying. what I'm trying to understand is, do you wish to dismiss the remaining claims in this case, or does your client wish to dismiss the remaining claims in this case or not?
Yes, he does. He does.
Okay, so if this case were remanded for such a dismissal in the trial court, you would be filing a dismissal of the remaining claims? And again, this is your choice. I'm not making you do this, to be
Your
clear.
Honor, it's not my choice. It's my client's choice.
But that's what I'm saying.
And it is my understanding that is exactly what he would instruct me to do.
Okay, here's what one way of dealing with it could be: we could send it back to the court, give a limited period of time within which to resolve the remaining claims if we think it's interlocutory, and then bring it right back up and pick up where we left off, as opposed to starting a new appeal.
Your Honor, my concern there is exactly what was pointed out in my arguments why the exceptions should govern, because the passage of time is inflicting a lot of pain on this estate, and it's not just financial; it's emotional. A fiduciary should be appointed. The court designated that fiduciary, and as soon as that order was granted in my client's favor, we requested an accounting. We requested possession of the property, and the excuse that was given for not turning over possession of the property and not turning over an accounting was that the appeal created a stay.
So can you be more specific as to what rights would be irreparably lost?
Certainly, Your Honor. Once this appeal is dismissed or remanded, it's my understanding that my client will be allowed to act as trustee. And if the final order is appealed and this court decides that he should not have been trustee, the appellant's client can't then re-administer the trust because it's already been administered. So it's a property interest. The trustee's fiduciary role is a fiduciary property interest that this appeal hopefully will adjudicate once and for all. If that fiduciary property interest belongs to Mitchell Brown or if it belongs to Diahanne Morse. And if this court decides not to adjudicate that, my client is going to carry out his fiduciary duties as trustee and administer the estate. And that can't be undone if a final order is appealed and the final order disagrees with the trial tribunal's decision that Mitchell Brown was the trustee.
Is there a dispute as to whether the dismissal should have been with or without prejudice?
Not in my mind, Your Honor.
No, I know, but is that an issue before us today?
I don't believe it is. Ms. Thiem didn't mention that in any of her argument before the court. Well, she mentioned that she thought it was a dilatory tactic to ask for it to be dismissed without prejudice.
Her brief states as issue 5, whether or not the court should have granted the motion to dismiss appellee's claims without prejudice.
Yes, Your
And the
Honor.
dismissal of the appellant's counterclaims as moot. Sounds to me like it is an issue.
Yes, Your Honor. I stand corrected.
Does that affect how we should consider whether this is an interlocutory appeal and the remedy that is being floated here to resolve it?
I hadn't given that thought because I was focused so much on the prejudicial effect of a trustee administering the estate or not administering the estate. So I hadn't given it a lot of thought. It seemed to be a collateral issue. Again, going back to the collateral issue rule.
Well, wait a minute. Isn't the appointment of who's the proper, or the determination of who's the proper trustee in this case, isn't that central to all of the claims? In other words, it's not the only part of the claim that was asserted here. Certainly, there were other claims, but that's sort of step one in all of the claims, isn't it? I mean, there's no fraud claim if she's necessary. There's no claim against her if she is the proper trustee.
Your Honor, if I understand you correctly, are you referencing
The idea that
support
it's
of the
a,
collateral rule.
correct, the idea that it's
Yeah.
a separable or collateral issue. I mean,
Well,
it's not a collateral issue, it's at the heart of everything.
The collateral issue means in my reading of the case law, it's collateral to the other issues, not that it's not central to the importance of the case. So the gravamen of this case is I view it as a wrongful act in a general term. And similar to the Zimmelman case, the collateral issue was whether a bank could have a referee collect the rent pending the foreclosure. And the debtor in foreclosure said, well, if you're going to collect the rent, you're going to use to fuel the litigation. So we don't think you should be allowed to do that.
What was the central issue?
In Zimmelman, foreclosure.
So the side issue you're talking about is collateral, really was collateral there.
Well, I think in this case, it could be argued as collateral because it can be independently decided apart from the gravamen, which is basically fraud. If these documents...
But the gravamen relates to who is supposed to be the appropriate trustee at this point in time. Isn't that central to, as the Chief Justice was saying, to this entire matter?
I'm trying to draw a distinction, Your Honor, and I do agree with your characterization of it as central. Of course it is central. But I do think it can be decided independently of the other issue, which is, was it done intentionally? Fraud requires intentionality. So we certainly need to discover who the trustee is. I think that is a final order. I think it's also collateral in the sense that it can be decided apart from the fraud issue.
There don't appear to be additional questions. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
And Attorney Thiem, you reserve 3 minutes for rebuttal.
Just to pick up on the issue of the trustee, yes, it appears that the case, even though there were multiple other claims brought by the appellee, that the central issue or wish of the appellee Mitchell Brown was to be the trustee. And so that is the central issue. I obviously respectfully disagree that this isn't a final order, but if the resolution of this court is that it is remanded for an entry of a final order, however that may be, with appellee filing a more complete motion to dismiss and having the judge rule on it, as long as we can come back to court, pick up where we left off so that it's not an additional time spent rebriefing the same issues.
If when that happens, if it's remanded and the plaintiff files a motion to dismiss counts 5 and 6 without prejudice, what will your position?
Well, I mean, part of my argument in my brief was that this is very unusual to have a case, first of all, it's been 4 years since the case was started, then to file a motion to say, oh, by the way, we found out that none of these things are true, and therefore we're dismissing our claims. And then the court says, oh, you can have it without prejudice, so you can bring it back again.
So I take it your position, you might oppose that.
I would oppose that, particularly since...
So it's not just as simple a matter as remanding it to the trial court for entry of final judgment dismissal without prejudice. There would have to be some further consideration by the trial court as to whether it's going to be a dismissal with or without prejudice, wouldn't it?
That's correct.
Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we will be taking this matter under advisement. We issue a written decision in due course. And with that, we will be in recess on this matter.
All right.
seated. The matter before the court is Kennebec 25-169, State of Maine versus Peter Cayouette. I see counselor present. I'm assuming you're ready. We are being streamed live, both by audio and video. Before we begin the argument, if counsel would introduce yourselves for the record by saying your name together with the party you represent.
Good morning, Your Honors. Jamesa Drake on behalf of the appellant Peter Cayouette.
Good morning, Jake DeMasi on behalf of the appellee of the state of Maine.
Thank you. And Attorney Drake, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you. May it please the court and counsel. By its own admission, the state withheld Snapchat evidence that it deemed incredibly significant to its case in violation of its discovery obligations. And for that, Justice Lopez imposed a punishment. The state was prohibited from using the Snapchat messages in its case in chief and on rebuttal. Justice Lopez also properly denied defendant's request for a continuance to investigate AK's sexual history because such an investigation would not have uncovered any admissible evidence. The state does not take issue with either ruling. It didn't take issue with them before the first trial, and it doesn't now on appeal. Instead, 20 days before the second trial was scheduled to begin, the state asked Justice Mitchell to reverse Justice Lopez and to allow it to use this incredibly significant evidence on the theory that defendant had enough time to investigate. Investigate what? The only thing defendant wanted to investigate was AK's sexual history, and the fruits of that investigation would not have been admissible. The sexual proclivities of a 12-year-old are not admissible in Maine courts. That's what Justice Lopez ruled, and again, the state makes no argument otherwise. Nevertheless, right before the second trial was scheduled to get underway, Justice Mitchell ruled that the state's evidence, which again was withheld in violation of its discovery obligations, could now be used because defendant had sufficient time to find Callie. And in so ruling, Justice Mitchell not only ignored the unassailable evidentiary basis for Justice Lopez's ruling, he also endorsed the fiction that Callie could be located, even though defendant had no reason to try and locate Callie because he reasonably relied on Justice Lopez's ruling as law of the case. Respectfully, Justice Mitchell's ruling was wrong, and the error was deeply harmful to the defendant. The Snapchat evidence was the only evidence the state had of AK contemporaneously reporting abuse. The prosecutor mentioned the Snapchat evidence no less than 6 times in summation and told the jurors that the Snapchat evidence proved that AK was telling the truth. The first question the jurors asked in deliberation was the date of the Snapchat message. When the Snapchat evidence was omitted, the jury could not reach a verdict. When it was admitted, the jury voted to convict. Justice Mitchell's error was not harmless. Vacator on all counts is required. I'm happy to answer any questions the court might have.
Then going to the issue that you've just discussed, you said the error was deeply harmful. But it sounds like what you're saying is that the error was deeply harmful because the evidence itself, the Snapchat, was very harmful. It was very powerful evidence for the state's case, and so in that sense, harmful to the defense case. But it seems that what we have said in discovery issues is that the violation must have been prejudicial to the defendant, not because the evidence is harmful, but you have to be prejudiced by the violation, by the failure to turn it over in a timely fashion. And it seemed like what you were focusing on is how powerful the evidence was for the state. And that's not a matter of being harmed by the timeliness, because it would have been powerful for the state if they had turned it over in a timely fashion. So I'm a little confused by how there's prejudice in that sense of not from the evidence itself, but by the delay.
So it's curious because the nature of the ruling here is somewhat curious. We certainly agree with the state's characterization of this evidence. It was incredibly significant. It was incredibly powerful.
Certainly.
No one doubts that. But the Snapchat message in full, right, not just the portion that was admitted, but the entire Snapchat message could have, at least this was the defendant's argument, it could have had impeachment value. And Justice Mitchell's ruling seems to suggest, because he's saying you could have investigated, you could have found Callie, you could have done the investigation that you wanted to, that might have netted impeachment evidence. In other words,
but it doesn't matter what the grounds is in that sense. I mean, his comment, well, you could have investigated. It doesn't matter. Let me back up. Isn't really the unfair surprise the sine qua non for a sanction in a discovery violation? And it doesn't matter if it means you would have further investigated, that you would have changed strategy, that you might have investigated a plea. There's all those things that if you don't have the case on the eve of trial. But it's the last minute unfair surprise, and that was cured when 11 months passed.
so first of all, this is not, the question is not, is 11 months sufficient time to investigate evidence that's 7 years old? Because what we're dealing with, it wasn't until 20 days before the trial was scheduled to begin that the state expressed any interest in trying to get this evidence in. So it wasn't until 20 days out that the state says, we're going to try and attack law of the case. So the question in terms of the feasibility of the investigation is what could be done in 20 days with a witness who has a common first name, an unknown last name.
So is law of the case the basis for your argument then?
Law of the case is certainly a component.
Well,
I know
here.
Well, wait a
you
minute.
mentioned it, but
Isn't this a problem? Because haven't we said in State versus Como, we have previously indicated that law of the case doctrine does not apply when a mistrial has been declared in a proceeding in which a determination was made on the admissibility of prior convictions. Jurisdictions vary as to what deference they give when there's been a mistrial. And we fall into the category of no law of the case under Como and under Chubbuck.
Yes, and jurisdictions also have varying definitions of the law of the case doctrine. The law of the case doctrine is itself sort of multifaceted. If this court doesn't want to focus on the concept of law of the case, then I would suggest, and this is a response to Chief Justice Stanfield's question as well, the underlying evidentiary ruling that Justice Lopez made is unambiguously correct. There was no need, regardless of surprise, regardless of the feasibility of an investigation, this investigation never would have uncovered anything that would have been helpful to the defendant. The defendant never would have been allowed to present evidence about AK's sexual history around the time the Snapchat message was made. And so whether the defense is relying on that ruling specifically from Justice Lopez, whether the defense is relying on just sort of common sense knowledge and understanding of Rule 412, in either case, the defendant had absolutely no reason to undertake an investigation in the 11-month period between the first trial and the second trial.
And I understand that. I'm still not understanding why there's any other unfair surprise in terms of that evidence is coming in when it has been in the possession of the defendant now for 11 months, unlike at the time of the first trial.
So the part that came in, I'm sexually abused every night except when I'm on my period, no surprise there. But the surprise is, if I had done an investigation and learned what was going on with AK at the time, then I could have presented that as well as impeachment evidence. That's the investigation that the defendant wanted to do. That's the investigation that Justice Lopez couldn't be done.
But you could have done it, and you could have, for the same reason that the Justice Connors just said, law of the case may not apply. I mean, you may very well have been able to get a different ruling from Justice Mitchell, or you could have tried, as to what was admissible from the defense point of view, had you had information you wanted to present.
This court should absolutely not issue a decision suggesting that the state can skirt the discovery rules around an incredibly significant piece of evidence to its case, and the defendant is entitled to no remedy because he should have anticipated that a judge would ignore the rules of evidence. And we're not talking about ambiguity in the rules of evidence. I mean, the clear articulation of the rules of evidence, and hope that he could find a judge that would somehow go along with him in the folly that this evidence might have been admissible.
Counsel, in the first go-around before Justice Lopez, was the request for a motion, request for a continuance, an alternative remedy that the defendant was seeking?
Yes.
Why? If,
He
if
wanted to-
if investigation was not going to be helpful, why was he seeking a continuance of that?
He asked, remember, this was all fairly breaking news to him that this evidence existed. He said, I would also like a continuance in addition to the evidence being prohibited so that I can try and find Callie and so that I can figure out whether AK was engaging in any inappropriate sexual behaviors. That's what we have as our record evidence here. I think he wanted to do that. He says, listen, I think I might be opening myself up to a claim of misconduct if I don't sort of make this request. But nobody is suggesting that Justice Lopez's ultimate ruling on that issue was wrong. I'm not up here challenging that ruling by any means. The state never takes issue with it as well.
also-
Can I
really
ask
says-
you, in the minute you have remaining, just to talk about the court's response to the jury's last note?
Yes.
As I understand it, the jury sent out a note, and the parties are trying to decide how to respond to it, and that the court adopted the exact response that Cayouette suggested. And now on appeal, he's arguing that that was error.
Error of a jurisdictional nature. So we sort of make two alternative arguments about that, about the validity of count 4. But the one that I would like to use my time to discuss is the court had no jurisdictional authority to enter a conviction on count 4. And so when giving its instructions, regardless of whether they were the ones that defendant requested, because jurisdictional issues can't be waived, the court had an obligation to tell these jurors, as it should have told the jurors when it came in as seemingly other acts evidence, this can only be used for propensity purposes. You cannot use this as a basis for your conviction. It's very clear from the jury's dogged questioning about this babysitting incident that they were keyed into this
But
event.
they'd already been told that they couldn't use what was the alleged act that day. In other words, the touching of the breasts, that could not be the basis for the conviction.
If I may.
Yes.
AK's testimony at the second trial was not that her breast was touched the morning of the babysitting incident. Her testimony, and this is the second part of our alternative sufficiency argument, her testimony is, he touched me under my shirt, and she never specified any particular body part. So the jurors were told, yes, that doesn't qualify, that's not good enough. But then when they're asking a very directed question about whether count 4 can be used as the basis for their conviction, the trial judge should have said no, in much the same way that the court should have given a limited or a cautionary instruction when that evidence was introduced in the first instance.
Thank you.
Thank you.
Good morning, Chief Justice Stanfill, Associate Justices, and may it please the court. The central issue in this case is whether a trial court is required to exclude evidence when a discovery violation occurs 11 months before trial. In State v. Lowry, this court has said that this court will only reverse for a lower court's determination of an appropriate discovery sanction if a defendant has demonstrated that he was prejudiced by the discovery violation and that the prejudice rose to the level of depriving him of a fair trial. To date, from the state's perspective, there has been no prejudice that's been shown. As my colleague has just argued, any investigation that would have occurred would not have generated anything helpful to the defendant. Certainly, in the instance of the first trial, when this evidence had only been made aware to the defense attorney after jury selection, that was the unfair surprise. It was just too soon, and Justice Lopez at the time made a determination that the state was going to be excluded from using that evidence due to the unfair surprise. 11 months later, there is no unfair surprise, just as Justice Mitchell said, as he held. And I think I would like to respond to this kind of the notion that defense counsel at trial had no idea that the state was seeking it. I think in the transcript from the argument, you can see that the trial defense counsel
Are you
wasn't
talking about the argument, the second trial?
Yes.
Okay.
The trial counsel wasn't arguing, whoa, I didn't know the state was ever going to be attempting to admit these, because certainly there was plenty of discussions, which of course aren't on the record, but plenty of discussions about the fact that the state was going to be intending to admit these. And also, as Justice Connors noted, as a result of a mistrial, the notion that an evidentiary ruling that had occurred previously was automatically going to be the exact same thing wouldn't have been a correct assumption.
Counsel, can I turn to the sentencing, though, in this case? So at page 58 of the sentencing transcript, Appendix 38, the sentencing justice says, other aggravating factors the court takes into account are the failure, I believe the failure on the part of Mr. Cayouette to show remorse or take responsibility in this instance. What is the evidence that he was not remorseful or failed to take responsibility, other than that he had a trial?
Of course, Your Honor. The evidence was the content of what he testified to.
Point something specifically. I mean, I've read his testimony. It was actually fairly innocuous, and he basically said, I didn't do it.
Well, I think from the state's perspective, I would disagree with that, in that there was a lot of discussion about the toxicity in the house, and that essentially the victim in this case had an attitude problem as it related to jealousy about...
And both things can be true. He can be guilty, and she may have been toxicity in the house.
And certainly so, and the sentencing court could have said, I take him at his word on that point, but the trial court didn't do that. The trial court was there to observe the testimony, was there to see the way in which the defendant testified, and he made a finding that the defendant had testified dishonestly on that other point, and that...
And that's a little easier. I didn't do it, the jury says you did. But I'm really struggling how somebody can ever, if they are denying the charge, having a trial, and denying that they committed the offense for whatever purpose and in whatever way, does that mean it's always a failure to take responsibility and failure to take remorse? And if so, as an aggravating factor,
the sentencing court...
as opposed to a neutral factor? Clearly, they didn't take responsibility and didn't express remorse, and those can be mitigating factors. And I think we laid that out pretty clearly in Woodard, and then again, more specifically in Ellis.
So to answer your question, I think that sentencing courts have broad discretion, and to specifically attempt to lay out exactly what it would require to hit that level of a showing of lack of remorse, I think would be challenging for this court. I think in Grindle...
But you agree that the fact that you have a trial and contest the charges can't be used to show lack of remorse and lack of responsibility. You agree?
I certainly agree.
The fact that you testify and generally dispute the charges in your testimony could not be a lack of remorse or lack of responsibility, can it?
Not on its own, no.
Okay. So what is it in the testimony in this case? Did he allocute at sentencing?
No, he did not. And I think that gets to my point about in Grindle. There was clearly a discussion about usually lack of remorse is shown in the testimony. And if you don't allocate at sentencing, but you do testify, then I think that a judge can say that I watched you testify, I heard your testimony, and I did not think that you demonstrated any lack of remorse
But
whatsoever.
I guess I'm struggling to understand how one would demonstrate remorse and take responsibility if you are disputing the charge.
So, I mean, to paint a hypothetical, and I don't know if this would get the job done, but essentially, if a defendant were to go up there and testify that I feel so horrible about the impact that this has had on the victim, clearly something has gone wrong. Of course, I didn't do this, but there's something going on with her, and I feel so bad.
Well, now you're victim blaming, you're saying.
Well, certainly I'm not.
And then that would be something concrete if you did that, I suppose. I mean, I think in Woodward, there was something like that. When the defendant allocated, it was a very I'm really sorry, this has ruined my life, that kind of thing. And so the judge, we said, was fair in taking that as expressing a real lack of responsibility and lack of remorse.
But the defendant accusing the victim of lying as to the circumstances show a lack of remorse?
I think it could. I think that there could be a situation where a defendant testifies that, that the victim isn't intentionally lying, they're not intentionally making anything up, but, something's gone wrong here, and no, I'm not guilty, this was a misunderstanding or something of that sort. And again, I think there's broad discretion for the sentencing courts to make these determinations. I think that
It's clearly case by case.
it's always going
But
to have.
as we try and gravitate to a bright line, if in a trial a defendant doesn't testify on his own behalf, doesn't allocute, and it goes to the judge, can the judge, under any circumstances there, use lack of remorse as an aggravating factor at step 2 of the Huey analysis?
So I don't believe so unless there was some other evidence presented at the sentencing or in the trial about his conduct after whatever event had occurred.
So there is something of a bright line. You say there has to be something more. Just the fact that they didn't acknowledge it, didn't express remorse, can't be used as an aggravating factor. I know the defense bar is always in a quandary. They have a client, and they know if he gets up there and falls on the floor and admits what happened and express remorse for what they did, then that will not be might be a mitigating factor. But the client disagrees with that. It places a real Hobson's choice in front of the defense bar.
I mean, what we said in Ellis is a defendant's sentence may not be increased because he chose to forego expressing remorse or taking responsibility at trial or sentencing.
So my reading of that case suggests that if you don't testify and you don't allocute at sentencing and there's no other basis for the court to find anything relating to remorse, then it would be improper for a sentencing court to aggravate the sentence, because that makes it very clear that there's simply nothing there without the
So
state
you get
admitting some sort of-
penalized if you do go to trial and if you do say something on the stand.
Well, it depends on what you say. So again, this goes back to Grindle talking about
Presumably, you're not going to be admitting guilt, so we know that.
So, but I think if we go to the quotations from Grindle, which are suggesting that you're free to testify, but you're not free from any sanction for the things that you testify to.
This is a gray area, as has been noted, and it's a difficult one, I think, for sentencing judges. But your point about Grindle, I think, stands. I mean, Grindle was pretty clear that exculpatory testimony itself could be the basis for an aggravating factor. And I would suggest that a trial judge who's presiding at a trial, just as one has to judge demeanor, there's some intangible, potentially some intangible factors that go into play there. I don't know what the situation was in Grindle, but I'm just suggesting it's a pretty clear marker, in my view.
Exactly, Your Honor. And I think that over the course of this court's jurisprudence on the issue, there has been a repeated discussion about the trial court being in the best position to make these determinations. That goes beyond this issue specifically. That the trial court, who is there to observe the testimony, see the live testimony, hear the tone, listen to the words, and observe the entirety of the trial, they're in the best position to determine whether a defendant has shown remorse or determine whether a defendant has testified honestly. And again, as has been asked, if a defendant doesn't testify and doesn't allocute and never says anything and there's no evidence whatsoever one way or the other, then I agree that it couldn't be aggravated. But that's not what happened in this case.
That's the bright line. And I take it is your position that the other things that the justice said here during sentencing, after saying, I believe it's failure to show remorse, to take responsibility, that what the court said after that backfills the other element that you're talking about?
Yes, exactly. I think he talks about more specifically cabining it in the discussion of the defendant's testimony. I also think that from my reading of the sentencing indicates that certainly to Justice Mitchell, the most significant factor was the impact on the victim in this case.
And I understand that, but we've also sort of said basically, once the judge says, I considered this as an aggravating factor if, and I understand that's the if, it's not a proper factor, we kind of have to take that at face value.
And so I'm not going to fight you too much on that, Chief Justice, but certainly in this case, the tone and demeanor, according to Justice Mitchell, the words that were said, the content of the testimony led him to make a finding that the defendant had not shown any remorse, showed a lack of remorse, and that he had testified dishonestly.
And I guess my point is, isn't not showing remorse not the same as he's not remorseful? They're really two different things. One is neutral, and one is being used as an aggravating
So I think we're getting back to the bright line rule
Yeah.
that Justice Meade was
No,
asking
I mean,
about.
that's a problem. It's a struggle. I'm not.
And so I think that when a bright line rule isn't possible or is unworkable from this court's perspective, the proper way of handling that is to continue to allow the trial courts to
Or
make
another
those
way of
determinations.
handling it could be to say, stop using lack of remorse or lack of responsibility, taking responsibility as an aggravating factor. Taking responsibility, showing remorse are appropriate mitigating factors.
And certainly you could do that, but that would be overruling a significant number of cases from this court's
But
jurisprudence.
how logically can you go and take the position at trial, I didn't do it? Do they have to say, but if I did do it, I'm really sorry? I mean, isn't it kind of antithetical to defending yourself? To show remorse for something saying you didn't do?
So I think that,
Or
first off,
not taking responsibility for something you said you didn't do.
and I think it's different than merely not taking responsibility to some degree. It's also about remorse, and after you've been convicted, perhaps that changes. I mean, I take the point, and I'm not going to argue that this is the most obvious case to ever come before this court, but nonetheless, what this court has said previously and what Justice Mitchell surely relied on based off of the memorandums
Well,
which
do you
were...
think it's a good idea? Okay. If
We
we're-
can overrule cases.
I mean, how does that make sense? What do you think the rule should be?
Well, Your Honor, obviously it's not my place to determine what rules should be made, but what I would
Sure,
say...
we're saying we might overturn this. What do you think?
I don't think it should be overturned, Your Honor. I certainly do not, because I think that at sentencing, perhaps, if somebody is to say, you know what, I made a mistake here, and yeah, I was at trial and I had my trial and I testified and I said I didn't do it, but now that this has happened, I'm admitting that this happened and I take full
So
responsibility.
now I'm
that it should be
admitting I
rewarded for that.
perjured myself? That's a little bit of a problem,
So-
isn't it?
so
Why would
certainly, Your Honor,
anybody ever
But I
do
think
that?
if we get to the extreme cases,
And his appeal is probably still pending at that time.
But if we get to the extreme cases of extreme showing of lack of remorse, them saying, you know, horrible things, whether that's in testimony, whether that's in other evidence after the case, whether there's a subsequent investigation which occurs, if that were the case, and certainly in that case it should be
But
aggravated
it could
because it's
probably
relevant.
then be wrapped up into other language, right? Like he lied, or really, you know, did a lot of things that were unnecessary in terms of putting a victim through something.
Well, I think putting the victim through something gets closer to a separate issue, but regardless, I think just changing the words that we use
Well,
to
I
get
used
to
the
the same
phrase that were
thing.
unnecessary in order to have a trial or deny.
Is
Sure.
the entire concept hitched to the fact that we, or the judge, feels that a certain act would require contrition and remorse, just because he's a killer without remorse, that puts them into an aggravating scenario or characterization? Is that a justification?
Certainly, Your Honor, I think that would be exactly proper in step 2 of looking at the individual characteristics of this defendant, and so I think that would be proper.
Thank you.
Thank you.
Attorney Drake, you wish to be heard in rebuttal?
Yes, please. May I suggest some bright lines? Courts who have been confronted with this question have taken two broad approaches. One approach, the approach taken by the Fourth Circuit, by the Massachusetts Supreme Judicial Court, this is all addressed in our papers, is that if a judge suspects mendacity, that matter should be referred to the prosecutorial authority and the sentence should be left alone. The judge does not have the authority to charge, to evaluate, and
Well,
to
we
punish.
understand that, but are there circumstances under which a failure to show any remorse, you know, just a hard failure to show remorse, can possibly be an aggravating factor?
So I'm speaking to the issue of mendacity. If we move to the issue of remorse, there are a couple things to be said about that. The first is, I think it's very dangerous for a judge to control for gender and cultural and socioeconomic differences, read the mind of the defendant who is asserting permissibly all of these constitutional rights and say, you just don't feel really sorry, okay? Especially if the defendant hasn't allocuted. So could there be a hypothetical case where the defendant allocutes and says something just completely outrageous?
Which is actually what happened in Woodruff. It was at the allocution assent, there was a...
But not what happened here, right? So that's sort of remorse and responsibility. If there's no allocution, how?
The defendant is disparaging the victim throughout the course of his testimony. Saying, yeah, no, I didn't do it, and by the way, so-and-so is lying, I've never involved, et cetera, et cetera.
Oh, no, that is not disparaging the victim. That is asserting one's innocence, which is the defendant's constitutional prerogative and which cannot be punished.
So would you suggest that the bright line then is that what I said earlier, which is although taking responsibility and expressing remorse may be mitigating factors, their absence is not an aggravating factor?
Yes, and if we go back to the issue of mendacity, the bright line there is something like what this court has already said in the Plant case. If the defendant testifies and said, I only had 2 beers, but the blood alcohol evidence is that he had way more than 2 beers, maybe there's evidence of mendacity. The defendant says, I never went to McDonald's. The surveillance footage.
You only got 30 seconds left. Can I take you back to remorse again?
Yes.
Maybe a bright line on the other side. During the investigation, the police take this person accused of killing somebody, and he says something like, he deserved to die. I'm happy that he's dead. But he doesn't testify at trial, and he doesn't allocute. Doesn't that create a bright line to say that that was a lack of remorse?
I think that I would like the opportunity to research that and see what other courts have done with that. I'm not prepared, candidly, I'm not prepared to take a position, but I'm deeply uncomfortable with this notion that judges can intuit what's going on in the mind of a defendant who is remaining silent at sentencing. Thank you.
Thank you. Thank you, counsel. As is our usual practice, we'll be taking this matter under advisement and issuing a written decision in due course. Thank you.
All right.
The next matter that we have is Ellsworth Solar versus the Public Advocate and the PUC. And this is PUC docket number 2560. We are being streamed on the web, both by audio and by video. And I see counsel are present, lots of counsel are present. And I'm assuming ready to proceed. What I would ask is those of you who are going to argue before we begin, that you please identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good morning. My name is Hans Eisenbach. I'm on behalf of Ellsworth Maine Solar LLC, appellant.
Daya Taylor, Maine Public Utilities Commission.
Brian Marshall for the Office of the Public Advocate.
Thank you. And Attorney Eisenbach, if you wish to present your argument, we're happy to hear it.
Thank you. May it please the Court, my name is Hans Eisenbach, lawyer on behalf of Ellsworth Solar Maine LLC. And we're on appeal from a commission order that's barring Ellsworth Solar's fully constructed generator from participating in the state's energy billing program. Reversal is required here because the commission, in denying the exemption request to accommodate the late start of commercial operation, has erred as a matter of law and otherwise abused its discretion in failing to apply its established policy for these exemptions based on utility equipment delays that are outside of the developer's control. And the generator in question here met the legislature's two-part test for good cause exemptions. It established external delays from utility equipment delivery that was outside of Ellsworth Solar's control, and without those delays, the generator would have met the COD deadline. That's the test that was set out by the commission in two prior cases that were applying the standard in identical circumstances of delay with the same piece of utility equipment ordered in one prior case on the same day as the utility ordered the equipment at issue for Ellsworth Solar. And the treatment of these analogous fact patterns in different forms of relief is an abuse of discretion. In Pembroke Solar and Ellsworth Renewables, the facilities received exemptions based on an 11th hour and unanticipated change in the utilities equipment procurement schedule. And all the relevant facts here demonstrate that the same 11th hour delay as established by the similar interconnection milestones that were achieved here for Ellsworth Solar's generator as in these prior two cases. And namely, those factors are ISO New England approval. All these solar farms, including my clients, were in the same cluster study. They received approval on September 6th of 2022. And following that, they paid 100% of their interconnection costs, allowing the utility to begin the equipment procurement. Ellsworth Solar made its 100% payment in February, just like in Pembroke Solar's case, where they paid early in February 2023, and actually before the developer in Ellsworth Renewables had made their 100% payment. The beginning of construction was found as an important factor in all of these cases. However, in Ellsworth Solar's case, the construction timelines were almost exactly the same. Ellsworth Solar started construction on March 25th of 2023. It completed its facility, mechanically completed it, was ready for interconnection as of September 2024. And Ellsworth Renewables, one of these prior cases where the solar farm received the exemption, similarly had started construction in March of 2023 and completed the facility in October 2024. In Pembroke Solar's case...
Green light is on, so I want to make sure that I understand the nature of your argument. The PUC found that Ellsworth Solar failed to establish that it received the construction schedule from Versant in March 2023. Are you saying the PUC, as a matter of fact, that's clear error? Or are you saying that as a matter of law, it didn't matter that it didn't receive it?
Both. I think as a matter of law, the receipt of the construction schedule before starting construction is a red herring. And when and how the generator received its schedule did not matter in these other two cases. And
well, in the other two cases, they did receive a construction schedule initially that said it would be done in time. So as a matter of fact, they have identified a difference in the factual scenario in those other cases as opposed to yours, haven't they?
Well, so I think the distinction in treatment in the order that denies the exemption is based on one finding, that the initial, what was characterized as the first schedule, so on A11, and this is in the order on page 3, the order states that in June 2023, Ellsworth Solar received a construction schedule from Versant that estimated a commercial operation date of February 11, 2025. Versant states that this is the first construction schedule provided to the project, and it was provided at the kickoff meeting. Now, that's not what ODR 002 says.
Because that's a fact issue. You're saying that there were an error to find that that's the first construction schedule.
Right. So now I'm addressing the issue with...
Okay, let's focus on the clear error argument you're making. You're saying that they couldn't find that you didn't meet your burden of proof on this because you produced a copy of something that's dated in April 2024 as to whether you received something that said something in March early, 23.
Well,
23.
I think what, Justice, you're referring to is that the email delivering us a copy of that schedule was sent later in the lead up to our preparation of the petition for exemption, making sure that we had all of the
And we
schedule.
understand that, but I guess the question is, what is the evidence that would compel us to overturn the factual finding? I mean, they essentially said they don't believe that you got that schedule in March 27th of 2023. And that in fact, the first written schedule that you got, that they appeared that you got was on June of 23. What is the evidence that would compel them to find differently?
So the evidence of the timely communication of the March 2023 schedule is of record. And there are at least 3 places in A62. There's an April 5th, 2023 email that was sent internally amongst my client's staff affirming that Versant had timely communicated the information from the March 2023 schedule. On A86, there's a Versant discovery response that indicates in April of 2023 it communicated the scheduling of COD.
Well, that's if. It said if communicated.
No, it did communicate.
Oh, okay. I thought you just said if
No,
communicated.
in April of 2023, it's a Versant discovery response that affirms that they communicated the COD schedule as November 2024 in April of 2023. And that's information that came from that March of 2023 schedule. On A81, there's another Versant discovery response that affirms that the March 2023 schedule was created for Ellsworth Solar, and it lists out all these other subsequent schedules that identify exactly the extent of the delays. So the error of...
Well, like A81 is dated 2024. I mean, you cannot produce a copy of a schedule initially in March 23, 2023. And given that it's a discretionary exemption in the first place, and our substantive evidence rule, you had the burden of proof, if you can't produce the actual document and show that you actually received it on that date, and Versant has the citation saying it wasn't, then how are we compelled to say that it's clear error?
So that was what I was beginning to get to on the lack of evidence supporting this finding, that the June 21, 2023 schedule was the first schedule that Versant sent. That is not what the discovery response at A92 says. The discovery response says, when Versant delivered the initial project schedule dated June 21, 2023, it allotted 64 weeks of material procurement. Now, that distinction, initial schedule dated June 21, 2023, is not indicating that there was no prior schedule. What it's indicating is there's 2 June 21 schedules. There's a initial June 21 schedule, and then there's a revised 21 schedule.
It sounds like, if I understand it correctly, that the commission's decision not to grant the exemption was not so much based on the failure of one piece of evidence, but the lack of corroborating evidence, that the commission wanted more assurance of the dates and times. Am I correct on that?
Yes,
And
that's
what
correct.
do you make of that, the fact that the evidence was arguably shaky or not compelling, but no additional corroborating evidence was produced?
I think that hits on an important point, that there is evidence that shows that Versant was communicating the schedule at these relevant moments in the interconnection process. And this was the moment to be focused on the schedule.
And
all
you're
the
saying
things
that's
that we
enough,
made.
that you didn't really need any corroborating evidence to take it over the top?
Yeah, the idea that there needs to be further corroboration is a change in the standard. The idea that there's an email chain of custody requirement or something that needs to be proven out to show that we had a reasonable basis of reliance. Those are all, post hoc sort of changes of the standard that were not
Can I
noticed
shift
on
the
us.
discussion a little bit? Other than this disputed communication in March of '23, which I believe was a COD of 11/25/24 is your position, right? Other than that, starting with the June 23 schedule, that one had, as I understand it, a COD of 2/11/25. Is that right?
That's correct.
And were there any communications, any schedules after June of '23 that had a COD in 2024?
No, there were not.
Is that the problem? In other words, that when it comes to, is that why this finding is so significant? In other words, that it seems that the PUC basically found that we don't believe that you got, and we've talked about that they don't believe that you got a schedule showing a completion in 2024, and that therefore any of these changes in dates, based on equipment, are not delays outside of your control, because you frankly never were going to complete it within 2024, no matter how much you raced ahead with your part of it.
So I think the question identifies an important part of this process. Both the utility and the developer do have to, move in parallel with their construction timing, and that is exactly what we were doing. There isn't a standard, either in good cause or in industry practice, that says you need to wait to start construction until you receive a written, hard copy of this schedule. The process is such that these things change all the time. There's bi-weekly meetings where new updated information is shared.
And I understand that, but isn't
that's
the crux here that from the commission's perspective, the completion date was always 2025? And I know you disagree with the factual finding underlying that.
Well, so the commission's own order finds that the March 2023 schedule exists. It set out the date for completion and interconnection in the end of November. And the idea that the schedule changed in June is consistent with that.
Well, aren't they saying you never received it at the time, March 27, 2023, that you didn't meet your burden of showing whatever was going on within Versant at that time and what schedules they were doing internally? You didn't get anything at that point.
I think the way that we understand the reasoning, to the extent that we do, which we don't fully understand it, we tried to get further findings, but those were denied, is that there is some new requirement in this case that they've established for proof of a hard copy of this construction schedule from the utility before you start, or before you can reasonably start construction. In our view, it's just a change in the standard, and that's not something that can happen at the close, after the close of evidence during a voting meeting like this. That's an
Thank you,
abuse
counsel.
process. Thank you.
Attorney Taylor?
Good morning, and may it please the court. The commission in this case issued a decision which is based on substantial evidence and consistent with past commission precedent. I invite your questions at this time.
Okay, let me Do I have it right that the PUC's position is they didn't meet their burden of proof to show they received a schedule initially that said it would be completed within 2024?
That's correct. While the petitioner did provide a schedule with that date, there is no conclusive evidence on the record to show that they received that schedule when they claimed they did. The evidence on this record shows that the first schedule provided by Versant was the June 2023 schedule.
Why does that
Why is
matter?
that relevant?
Well, the schedule in these procurement cases was very salient to the commission because it shows first that Versant has gone through its equipment procurement process. And those are the dates that are going to inform the schedule. Versant goes out to its vendors, its distributors, who it works with. They work up a schedule based on lead times. They work up a schedule based on their own internal construction schedules and policies.
But why does communication of that schedule to Ellsworth Solar matter?
Because it was an objective way of looking at the next steps in a construction process for these projects.
But if they had started the process anyway, what relevance is it that they have that date at that time?
I guess if you're speaking to their part, the project's part of the process, they can start that whenever they wish, whether
Exactly.
they have confirmation from Versant about a schedule at all. The part that the commission looked at was the schedule because it provides a sort of anchor in which you can measure further delays. Here you have a complete
So is
plan.
it as simple as if you're not given a schedule from Versant that says it's going to get done in 2024, given the provisions here, then it's not an external delay outside of control because it was always essentially going to be in 2025?
Exactly. From the beginning of the construction process, this project was scheduled to come online in 2025.
I mean, it doesn't have to do with whether Ellsworth Solar, I mean, if they want to complete their part of the project, in 2021 or whatever, I mean, that, even knowing it's going to be years, that doesn't really matter. It's on them. They may bear a bigger loss if they're unsuccessful, but that's their problem. It doesn't have to do with the good cause exemption.
Right. The good cause exemption requires them, well, the NEB law requires them to come online by 2024. If Versant can't predict you to come online by the deadline, then your risk at coming online and not participating in the program is greater.
I may be mistaken about this, so correct me if I am, but is it true that at the time there was no deadline?
There was no deadline. This law was signed into law later in the summer in July 10th of 2023. However, this bill in April and May of 2023 was moving through the legislature, and there were many solar companies that did comment on the bill, and this company should have had notice of the fact. I mean, in the emails themselves, the company does say that they are aware of the potential of this bill affecting them.
Well, and one point is that this exemption is a may, not a shall exemption. So the PUC gets to identify what it deems is relevant in its view, as long as it's not an arbitrary test, and as long as you don't deviate from your test. And they've argued both. They've argued you didn't apply this test with anybody else, and it's an arbitrary test. So what's your response to that?
This decision by the commission is consistent with both Pembroke Solar and Ellsworth Renewables. In both of those cases, those projects definitively produced schedules. They produced the emails showing that Versant delivered the schedules to them, to the project, much earlier in the process. They had a firm estimation from Versant that their project would come online prior to the statutory deadline in 2024. And it was much later in their construction and procurement process that Versant came back and revised those schedules.
But didn't Ellsworth Solar produce at least one document indicating a projected satisfactory date?
It's unclear from the record in this case, and
And is that why the commission asked for corroborating evidence?
the evidence in this case is the petitioner's own statements that they received the schedule.
Well, as he pointed out at Appendix 86, there's a statement from, I don't know, from a Brandon Bouchard that what was communicated was 34 weeks in March of 23. Is Brandon Bouchard, it says it's a response by Versant Power, so that's not just from the appellant.
The emails that the commission looked at were from the operative dates of, March 2023.
I understand there were other things in the record, and I think that's really your position, is that there was at least evidence supporting your position and what the PUC found. But to suggest there's no evidence that they received a schedule in March is really overstating the case, isn't it?
The evidence that the commission looked at were the statements by the petitioner, and then on the other side, it looked at the email chain in March through, say, June of 2023, as well as testimony from Versant saying that the first schedule that was delivered to the petitioner was in June of 2023.
I may be wrong about this, but in the other cases that were cited, the Pembroke Solar, Ellsworth Renewables, at the time they started construction, they were already subject to the 2024 COD deadline, correct? Whereas here, Ellsworth Solar was not at the time construction started. Is that distinction significant?
As far as I remember, yes, those were two larger projects. So their COD deadline was established in 2021. When the petitioner received its schedule in June of 2023, it's not yet subject to the deadline. That would happen about a month later. That would be officially put on notice that it was subject to the deadline. However, that doesn't negate the fact that even after it was subject to this deadline, they continued to press forward knowing.
Well, but don't they have to? Because part of the good cause exemption is that not only that it was delayed for external delays outside of the entity's control, but also you have to find, the commission has to find that without those delays, the entity could have reasonably been expected to meet the COD of December 31st, 2024, or before that date. So, I mean, they have to press ahead with the construction in order to show that that's indeed the case. I mean, in fact, in Snake Root, that was part of the problem, right?
Well, I think what the distinction is in this case is the construction schedule that the project received from Versant shows that they had no reasonable expectation to be online in 2024.
They had been subject to the deadline when they were a larger project, right? They downsized the project, I believe, did they not?
They did, and they
at
did.
the point that they downsized, they were subject, before they downsized, they were subject to that same December 31st, 2024 deadline, correct?
Correct.
But that reprieve dried up when the law changed.
Correct.
The statute grants a broad discretion to the commission. I mean, if you took that to the extreme, you could almost say, we win no matter how you slice it. Here, I think there's a requirement of good cause to grant the exemption, but is it the commission's position that it could deny the exemption without any standards other than the fact that it's the discretion?
I think the commission tried not to issue arbitrary. We tried to look objectively at every case that was before it and we tried very hard to come up with these tangible points in the interconnection process from which to look at the situations that each project was in.
Thank you.
Thank you.
Thank you.
And Attorney Marshall, do you wish to be heard?
Oh,
Good afternoon. May it please the court. Let me start with the factual issue, and I'll first observe that the theory of the case here from the developer has changed. When they presented this case to the commission, they said they had received a construction schedule in March 2023 and relied on that construction schedule to start site clearing. We now know that that is not correct.
Well, we don't know that that's not correct. I mean, they are still saying that they received that schedule.
Now they're saying that the schedule was, I think, orally communicated during an April 5th kickoff meeting, but there's a lot of written evidence in this case, not just an absence of evidence, and we asked in discovery for all written communications between Versant and the developer related to the project. They could produce no email.
And that brings it back to why I think the suggestion from the commission, and I assume from you, is that the factual finding that they didn't believe that they had a schedule with a COD in November of 24, that they don't believe that they had that schedule or had been communicated to them in March of 23.
That's correct, Your Honor.
But
And
it's not really a question of reliance, is it? It's more a question of whether that means that they could, that it's the external delays or what prevented the project from being completed by December of 24.
That's right, Your Honor. I think the construction schedule is so important because it ties back to the statute. And the statutory language says you have to have an external delay. And unless you have some expectation, some reasonable expectation about when you will reach commercial operation, you just have a lengthy process. And what this court said in Snake Root Solar is that a lengthy interconnection process is inherent in the normal process. It's not an external delay. And this court approved of that narrow reading of the statute, because remember, the purpose of this statute is to reduce the costs of the NEB program to protect.
To shut down the programs that don't, I mean, frankly, is what it is.
Yeah, so I think this construction schedule is critical, and I think that's why we're here today. And I would say it's not just a lack of evidence that the construction schedule was provided. There's a lot of written evidence, and I would direct this court to ODR 1-3. There's confidential emails that show all of the communications between Versant and the developer. And what you'll see is that as late as April 20th, Versant had not identified the relevant system impact study. This tells the utility exactly what distribution upgrades are necessary. If they didn't have that study in March of 2023, there's no way they could have put together a detailed construction schedule.
So does it all come down to simply whether there's sufficient evidence essentially to support the commission decision?
I think the clear weight of the evidence is that that March 2023 construction schedule was never shared with them. There was no site plan provided to the utility until April. A site plan tells the utility exactly where on the earth the generator is going to be. The utility needs to know that information to know, for instance, how many poles need to be constructed. You simply can't put together a detailed construction schedule until you have that information. I think it was in May of 2023 that the utility first did a site visit. So a personnel from the utility actually walked the site. And then Versant itself says this is the initial construction schedule when they send the schedule in June, and that has a 2025 commercial operation date. So
did it ever drop back into 2024 after
no,
that?
Your Honor, it never dropped back to 2024. There was some hope that maybe they could speed up the procurement timeline. It never happened. In fact, it got bumped back to March 2025, I believe. So the developer was never under any sort of reasonable expectation that they would be operational in 2024. Now, I think this is the whole ball game. In the Pembroke and Ellsworth cases, The developer had a construction schedule with, in both cases, April 2024 commercial operation date. This is certainly a reasonable test. We know that the statutory language is ambiguous. This court said so in Snake Root Solar. It's a line drawing exercise at that point, and this is the clearest place to draw the line. Do you have a construction schedule that shows that you will be commercially operational in 2024? Without that, you have to rely on a lot of hearsay, and so told me this, and we're relying on industry procurement timelines. It's a very unworkable standard, and I think more or less the commission has created a bright line test on, did you get a construction schedule that showed you would be operational before the commercial operation deadline? A subsequent delay to that schedule, they said, that can qualify as a good cause exemption. But in all other cases, we are going to find that these interconnection-related delays are not sufficient. Thank you.
Thank you, counsel. Attorney Eisenbach, I believe you reserved 3 minutes for rebuttal.
Thank you. As we started out, the path to 2024, when Ellsworth Solar started constructing the generator, was apparent by all the pieces of evidence in Versant's discovery responses, the March 2023 schedule, the idea that the commission created a bright line that's based on an email chain of custody handoff of a hard copy of these schedules is nowhere in the Pembroke Solar or Ellsworth Renewables orders. So if that is...
But do you agree that in those cases, they did have, at least initially, a hard COD from Versant or whoever of April or thereabouts in 2024, well within December 31st of 2024? In the Pembroke Solar and Ellsworth Renewables cases.
They did have schedules just like they had schedules that were generated in March of 2023 in this case. In Ellsworth Renewables, they had a schedule before they had made the 100% payment. So there's no way that that schedule was going to hold because none of the money was there to order the equipment. So the idea that there was some delicate sequencing of all these things, they were all supposed to go in a sequence, and that's the only way that you ring the bell of good cause, that's a change in the standard. That's not present in these prior two orders. Ellsworth Solar was watching Pembroke Solar get its exemption and was trying to decide what to do. As some of the questions earlier pointed out, it had to very carefully decide in 2024 what it was going to do. When it did have some hope because one piece of equipment was received early, they had to start building. And just like in these other two cases, they couldn't stop and they had to go to the completion. And so the idea that this receipt of an email is the deciding point, that's just not the bright line that was ever established. And there's no dispute that it was the procurement delays that pushed the schedule. That's all over the record, and there's nothing coming from argument from PUC or the public advocate that refutes that. They agree that these schedule changes were the same as in Pembroke Solar and Ellsworth Renewables. It's the same piece of equipment. One of these facilities is on the other side of Ellsworth. They're all running the race at the same time. They get, someone puts something in their way that delays them the exact same amount of time, but only two of them get the sort of acknowledgement that there was that impediment. And in our case, there's this sort of requirement for more evidence. We tried to provide more evidence post-judgment. It was ignored. So if there is a need for more corroborating evidence, we pointed out the pieces of evidence in the record already. We supplemented it with an affidavit from the utility about exactly what they were communicating with us in this operative, in this critical moment when, we were starting our construction and there was no deadline. So any reasonableness argument to support the order, just doesn't make any sense.
Thank you, counsel. As is our usual practice, we will, of course, take this matter under advisement and issue a written decision in due course. It is my understanding, Attorney Eisenbach, that this is your first appearance in front of this court. And as probably all know, it is our custom to invite call counsel back to take the greetings of the court, and we'd be happy to do that this morning. With that, we'll be in recess on this matter.
All right.